Hi, I'm Alan Beaver. Welcome to this episode of Understanding Tort Law. This is our first episode on the law of negligence. What we're going to do in this episode is I'm just going to very briefly introduce the tort of negligence, and then we're going to start talking about some aspects of the standard of care. This tort is without doubt the most important tort in the modern law. It's also a relatively recent tort, although, as is quite common, its history goes back a long way. You can trace it way back, but it's really only in the 19th century that the law as we know it starts to form, and most of the important cases come from a period around the middle of the 20th century. So this is pretty recent compared with, say, torts like battery and assault. Okay, the general question that this tort deals with is the question, when will someone be liable for unintentionally harming someone else? This is not the only tort that deals with this issue, but this is the most important tort that deals with this issue. When is someone going to be liable for unintentionally harming somebody else? And the general answer is when one is negligent. Okay, now immediately here we have a problem because this term negligence can refer to two different things, and we have to be careful about that. So first of all, there's what we might call the negligence inquiry, or the tort of negligence as a whole. And this tort is divided into various stages. Now, people divide this tort differently, and also when the cases come to court, they're not necessarily divided up in this way at all. But we can divide the negligence inquiry into various stages. I divide them into 5 stages, these stages. So first we have the standard of care, second the duty of care, third remoteness or legal causation, fourth factual causation, and fifth defences. Now lots of people, in fact I think most people will divide the inquiry differently. They divide it into 4 stages, standard of care, duty of care, causation, and then they divide causation into remoteness and factual causation, and then the 4th stage being defences. So in a way we all really agree with each other. It's just a question of how we divide it. Now I think my way of dividing it, for reasons that we'll see when we get to talk about remoteness, my way of dividing it actually makes much more conceptual sense. It'll make more sense to you as a student dividing things this way than dividing it in the way that people traditionally divide it. In particular, though you can refer to both the 3rd and 4th stages as causation. In fact, they have nothing in common with each other, and it's best to keep them separate. Anyway, we'll argue about that later. But here's the thing. When we mean negligence, when we use the term negligence, we may be using the term to refer to all 5 of these stages. For example, when we talk about the tort of negligence, or when we say the defendant was liable for negligence, we are referring to the whole inquiry, all of these 5 stages. But sometimes we use the term negligence to refer only to the first of these stages, to the standard of care stage of the inquiry. So for example, when we ask, was the defendant negligent? Chances are we're referring only to the first of these stages. Okay, so we just have to keep that in mind. We have to keep in mind that the term negligence can be used to refer to different things. It can be used to refer to the whole tort, to all of these 5 stages, or it can be used to refer to only the first of the stages. Okay, now it's normal, again, I'm not normal, but it's normal to start talking about the duty of care, but I'm not going to do that. I'm not going to do that because I think that it's not the best way of beginning. You see, what is this tort called? It's called negligence. So it's likely that your question is, the most natural first question to ask is, what is negligence? What is negligence? And the right way to answer that question is to focus on the standard of care. It's in this area of the law where we discover what negligence actually is. Now, some people will tell you that negligence is the breach of the duty of care, and that's why you have to start with the duty of care, because it's only once you've established a duty that you can work out how to breach it. I'm sorry to say this, but that's just wrong. Negligence is not a breach of a duty of care. You can be negligent without breaching any duty of care, and we will see cases like this. the standard that has to be breached in order for the defendant to be negligent is the standard of care, not the duty of care. Now, that won't mean much to you now. Just don't worry about it. You can just take my word for it at the moment that the question, what is negligence, is answered in the standard of care stage of the inquiry, and that's why we're going to begin there. Okay, now, what is negligence? The legal answer is that negligence is the creation of an unreasonable risk. Negligence is the creation of an unreasonable risk. Well, that just begs the question, what is an unreasonable risk? And the law's answer to that question is that an unreasonable risk is a risk that the defendant would be at fault for creating. Now, that's circular, right? We've gone around in a bit of a circle here because fault is going to be defined in terms of the creation of an unreasonable risk as well. But let's just live with what we've got for the moment. Fault, right? What's key in this area of the law is fault. Negligence is fault. If the defendant is negligent, then the defendant is at fault. The creation of an unreasonable risk is a creation of a risk for which the defendant is at fault. That, though, begs the question, how do we determine fault? And the answer is we have a standard of care. There is a standard that the defendant has to live up to. If the defendant doesn't live up to that standard, then the defendant is at fault. If the defendant does live up to that standard, then the defendant is not at fault. Okay, now a key thing to notice here is that this notion, the standard of care, is a threshold notion. You either meet the standard or you fail to meet the standard. It's like an on-off switch. The switch is either on or off. There's no sort of half on, half off. It's either on or off. You either meet the standard or you fail to meet the standard. You're either negligent or you're not negligent. There's no half negligence. There's no a little bit negligent. There's no 3/4 negligent, right? There's no a bit negligent. You're either negligent or you're not negligent. It's a threshold. And there's no heaps negligent. There's no massive negligence. There's no gross negligence, although we'll see that term crop up every once in a while. It's an old term. It used to matter in law, but it doesn't matter anymore. If you're negligent, then you're negligent. You can't be doubly negligent, 3 times negligent, 4 times, there is no such thing. So this is a simple on-off switch. The defendant is either negligent or not negligent, and that's it. We need to recognise that the amount of liability that the defendant will face does not depend on the defendant's fault. And the reason for this is that liability doesn't come in amounts. Again, liability is a threshold notion. The defendant is either liable or not liable. There's no amounts of liability. There's no degrees of liability. It too is a threshold notion. Okay, damages come in amounts. But damages are not the same as liability. This will become clearer as we go through. Okay, so we're dealing with a threshold concept. You're either negligent or you're not negligent. There's no half negligence, there's no a bit negligence, and there's no huge negligence, no gross negligence. That's simple on-off switch. Okay, now in determining where the standard lies, where the switch switches from off to on, if you like, there are 3 kinds of standards that we could adopt. These standards. First of all, we could adopt a subjective standard, or we could adopt the standard of strict liability, or we could adopt an objective standard. If we adopt a subjective standard, then we determine the defendant's liability in accordance with that particular person. So, we would look at the particular person and we would ask questions like, was this person doing her best? Was she trying hard? Was she able to avoid injuring the plaintiff given her particularities, her peculiarities, her circumstances, and so on? The second standard is that of strict liability. On this approach, we would simply ask, was the plaintiff injured? If the plaintiff was injured, then the defendant will be liable. The third standard, the objective standard, we determine the defendant's liability by reference to an ordinary reasonable person. So instead of looking at the particular plaintiff and asking what could have been expected of that particular person, we ask what would an ordinary reasonable person have done in the circumstances. This is important for us because the standard that is adopted in the law of negligence is an objective standard, not a subjective standard and not strict liability, an objective standard. So when we're asking whether the defendant was negligent in the law of negligence, we're not asking a question about the particular person. We're not asking a question about that particular defendant, given that person's abilities, disabilities, talents, circumstances, and so on. We're asking a question about how an ordinary reasonable person would behave in the relevant circumstances. Okay, and we can see this very clearly in the quotation from the following case from Blythe and Birmingham Waterworks, where it was said, "Negligence is the omission to do something which a reasonable man, guided upon those considerations which ordinarily regulate the conduct of human affairs, would do, or doing something which a prudent and reasonable man would not do." And a very clear and rather stark illustration of this principle can be seen in the following case, Vaughan and Menlove. Okay, so in Vaughan and Menlove, the defendant builds a rick of hay, that is, a haystack, on his own land, but next to the plaintiff's barn. So the plaintiff has built a barn on the plaintiff's own land, but it's on the border of the land, of the plaintiff's land, and the defendant builds a haystack next to it. Now, this is said to be a negligent thing to do because in the England of the day, I didn't know this, but apparently if you're a farmer, you'd know this now, that haystacks are prone to catch fire. And so you shouldn't build haystacks next to buildings because if the haystack catches fire, then the fire is likely to spread to the building and cause the building to burn down. And indeed, in this case, that's what happened. The haystack did catch fire, the fire spread to and burnt down the plaintiff's barn. Obviously, the plaintiff suffered a loss as a result of this. The plaintiff's very unhappy about that and is suing the defendant for negligence. Now, the defendant's response is to say this. The defendant says, in effect, this. Look, it may well be that a normal person, let's just use that word, a normal person would recognise that the haystack was prone to catch fire and that the fire would spread and burn down the plaintiff's barn. A normal person would realise that. But I'm not a normal person. I am exceptionally stupid. This is a case that proves that some people will do anything to win a case, right? I'm exceptionally stupid. I didn't know that the haystack was prone to catch fire and that the fire would spread and burn in the plaintiff's barn. An ordinary person might know that. A normal person might know that, but I'm not a normal person. I am exceptionally stupid. And you should judge me by a standard that I could meet. You have to judge me by a standard that's fair to me. It's not fair to impose a standard on me that I can't meet. It's not fair to me to impose the standard of a normal person when I'm not normal. I'm really thick. And you have to take that into account when you determine whether I was negligent or not. Okay, now, just an aside here. You might think, well, I'm not really sure that the defendant's telling the truth here. Maybe the defendant is, laying it on a bit thick, if I can get away with that pun, in order to try and win the case. Maybe he's not as stupid as he claims he is. But the thing to see here is it doesn't matter, because the court's position is, well, even if you are that stupid, you're still going to be liable. So it doesn't matter what the facts actually were. What matters is the facts as they were accepted by the court. We've talked about this earlier when we were looking at the law of nuisance. The facts as they're accepted by the court. And the court's position here is, look, even if you are as stupid as you say you are, you're still going to lose. So the question then is, why? Well, the first thing to be said here is to note that Tyndall says, the Chief Justice Tyndall, says that this is a case of first impression. Now, we talked about what that meant in the nuisance discussion as well, but let me just remind you. A case of first impression is a case that involves an issue that hasn't been before the courts before. It's a first impression, right? It hasn't been before the courts before. And so there's no precedent that determines the result that the court should reach. So in theory, or at least according to some theories of law, Chief Justice Tyndall was free to do whatever he wanted in this case. But notice that that's not how Chief Justice Tyndall approaches the issue at all. What he says is that there are general principles of the law that operate here and that received explicit recognition in other areas of tort law. He talks about bailment, for example. And the general principles of the law is the principle that an objective standard would apply here. Instead, therefore, of saying that the liability for negligence should be coextensive with the judgment of each individual, which would be as variable as the length of the foot of each individual, we ought rather to adhere to the rule which requires in all cases a regard to caution, such as a man of ordinary prudence would observe. Okay, so here, as well as in the Blythe case, we can see the focus not on the individual defendant, but on what would be expected of an ordinary reasonable person in the defendant's position. So in this case, in Vaughan and Menlove, the issue is not could the defendant have known that building the haystack was prone to catch fire if spread to them. The question is, would an ordinary reasonable person have built the rick of hay there? And the answer is no. An ordinary reasonable person would not have built the rick of hay there because an ordinary reasonable person would have known of the propensity of haystacks to catch fire and the fire to spread to the barn and burn it down. So an ordinary reasonable person would not have behaved this way, so the defendant is negligent. Okay, now there are various formulations, and we'll see some of these formulations as we go through the cases. Of the ordinary reasonable person standard. In England, the ordinary reasonable person is sometimes referred to as the man on the Clapham omnibus. This is obviously a rather antiquated expression, but the guy, just the person on the bus, the person on a bus in some city, London or wherever, just a person on the bus. In Australia, it's often said it's the man on the Bondi tram, although the man on the Bondi tram is likely to be in New Zealand, as it happens. But in any case, you get the idea. Just sort of an ordinary person, Now, in the past, we say man, the man on the Clapham omnibus, the man on the Bondi tram. Of course, we mustn't use that expression now. We are not. This is not supposed to be a gender reference. It's the person, or ordinary reasonable person, not the ordinary reasonable man. A person. Now, there are some people who think our very idea of the ordinary reasonable person is going to get us. There's very interesting work's being done on this. I won't talk about this here, but you might want to look out for it. But let's just say we're talking about the ordinary reasonable people, not men, people. Okay. Now, this case, Vaughan and Menlove, stands for the principle that the idiosyncrasies of the defendant cannot remove rights from the plaintiff. Think about what the defendant was trying to argue in Vaughan and Menlove. The defendant was trying to say that in determining my liability, you need to take into account the fact that I'm stupid. Now, you can see why, I think we can all see why that argument might be thought to be compelling. But the question is, how does the defendant's argument justify a conclusion when the conclusion will affect the plaintiff? Right? The question is, how can the defendant's stupidity justify removing the protection of the law from the plaintiff that the plaintiff would ordinarily have? Right? The plaintiff has a right to his barn. That right affords a certain level of protection. But the defendant is saying, but that level of protection should be lowered in my case because of my stupidity. And the response of the court is to say, no, your stupidity does not justify a lowering of the protection afforded to the plaintiff. If you like, your idiosyncrasy does not justify removing the plaintiff's rights. So this is a parallel of the case which we talked about when we were there, when we were talking about this. This is the parallel of the case that we looked at in the Law of Negligence, Rogers and Elliott. Remember, that case stood for the principle that the idiosyncrasies of the plaintiff cannot impose obligations on the defendant. This case stands for the principle, the parallel principle, that the idiosyncrasies of the defendant cannot remove rights from the plaintiff. So when we're deciding negligence, when we're determining negligence, we're not making a judgment about the defendant in isolation. What we're doing is making a judgment about the relationship between the parties. We're making a judgment about, it's only a partial judgment, there's these other stages in the inquiry that we need to look at, but we're making a judgment about whether the defendant is going to be liable to the plaintiff. Well, we don't do that by focusing solely on one of the parties. Okay, now with that in mind, we need to think about an important difference that exists here between the law of negligence and the criminal law. Okay, the default standard in the criminal law, at least if we're talking about crimes such as murder or crimes of violence, crimes to the person, property offences and so on, the default standard is a subjective standard. And the default standard here is not a subjective standard, it's an objective standard. So the question is, why the difference? Why the difference? And the answer, I think, is this. In the criminal law, there's been, in the cases that we're talking about, there's been some harm that's been caused to somebody. Someone's been killed, someone's being attacked, someone's property has been damaged, whatever it is, right? And the law can't do anything about that harm. The law can't do anything about the harm. The job of the criminal law is not to do something about the harm. The job of the criminal law is to work out whether the defendant should be punished for causing the harm. And the thought is to work out whether the defendant should be punished for causing the harm. The right thing to do is to focus on the culpability of the defendant, to ask, was the defendant sufficiently culpable to justify punishing the defendant for what the defendant did? So that involves a focus on the defendant. Was the defendant sufficiently culpable to justify punishing this person? Okay, so that's why the default standard in the criminal law is a subjective standard. In tort law, however, in the law of negligence, the issue is different. It's still true that tort law can't do anything about the harm, can't make the harm go away. So in Vaughan and Menlove, we have a barn that's been burnt down, and there's nothing that tort law can do about that. I mean, we can't sort of, undo the fire. The fire's there. But here's the question. In tort law, in the law of negligence, the question is, who is going to have to bear this harm? If there's no liability, the plaintiff is going to have to bear the harm. The cost of the barn being burnt down are going to have to be borne by the plaintiff. But if we impose liability on the defendant, the harm is transferred from the plaintiff to the defendant. We still have a burnt down barn, the harm's still there, we can't make that go away, but the defendant is going to have to pay for the consequences. In this case, the defendant will have to compensate the plaintiff, pay money to the plaintiff to compensate for the loss of the barn. So what we have in these cases is that we have two parties, and these two parties stand to gain and lose the same thing. If the plaintiff wins, the defendant is going to have to suffer the loss. If the defendant wins, the plaintiff is going to have to suffer the loss. So these persons, the parties, are in a position of equality. They stand to gain and lose the same thing. And so the law has to reflect this equality. It has to adopt a standard that is fair as between them, because the parties stand to gain and lose the same thing. Now notice that there's no equivalent of this in the criminal law. It's not as if the prosecution fails, the prosecutor's going to go to prison or anything like that. And so what we see in the criminal law is an approach that doesn't treat the sides equally, an approach that favours, for good reasons, favours the defendant side. We'll talk about this again when we talk about proof later on. So we have an approach that favours the defendant side on the grounds that the accused needs protection. But in tort law, it's different. In the law of negligence, it's different, because the parties stand to gain and lose the same thing. They have the same interests operating here. And so the law has to treat them fairly. We can't settle the defendant's liability by focusing solely on the defendant, because the plaintiff's interests are also at stake here. We have to adopt a standard that's fair as between them. Similarly, we can't impose strict liability, which would be great for the plaintiff, But we can't do that because the defendant has interests here that we need to take into account. So we don't impose a subjective standard, because while a subjective standard would be fair to the defendant, right, it wouldn't reflect the plaintiff's interest in the case, right? It would determine liability entirely in accordance with the defendant. If we adopt the strict liability in this context, then it'd be great for the plaintiff, but it wouldn't take the defendant's interest into account. It would determine liability entirely by looking at the plaintiff. The objective standard is designed to take both parties' interests into account. It is designed to be fair as between the parties. A standard that is fair as between the parties. A standard that is not necessarily fair to the defendant, not necessarily fair to the plaintiff, but a standard that is fair as between the parties. Now, so the upshot of this is you might well think, and you'd be right to think, in my view, that Vaughan and Menlove is tough on the defendant if you're focusing on the defendant as an individual in isolation. But the law can't have that focus. The focus it has to have is a focus on both parties at once. Its job is to do justice to both parties, and so it has to adopt the standard that's fair to both parties. And sometimes that standard is going to end in results that are bad, that are on the face of it unfair for the defendant. Sometimes it will generate results that are on the face of it unfair to the plaintiff. That's not the issue. The issue is whether it's doing justice as between the parties. And so when we're thinking about this area of the law, indeed when we're thinking about tort law in general, our focus should never be on one party in isolation. It should always be on both parties, because what the law has to determine is justice between two opposing parties. It's not enough just to be just to one party. You have to be just to both of the parties. So the law adopts an objective standard to this end. Now, there are some consequences of the objective standard that we need to look at, and they're summarized on this slide. So first of all, despite its name, negligence is not carelessness. In Vaughan and Menlove, the defendant was not careless. I mean, at least if you believe his story. Nevertheless, he was found to have been negligent. Okay, and the reverse can also be true. You can have someone who was careless, who isn't going to be found negligent, because the focus is not on the particular defendant, but on an ordinary, reasonable person in the defendant's position. The second point is that negligence is not a state of mind. When we're talking about negligence, we're not interested in what was going on in the defendant's head. Right? This is not a psychological inquiry. We're simply asking whether the defendant lived up to the standard set by the ordinary, reasonable person. Third, legal fault is not ethical fault. And what I mean by that is the legal fault, the fault that we're talking about in the law of negligence, is not what you mean by fault outside of this context. It's not what people talking down at the pub about what fault is. This isn't it. We have a special legal conception of fault that operates in this context. And the final point here is that a finding of negligence does not imply that the defendant is a bad person, or even that the defendant should have done better in the particular case. And if you believe the defendant's story in Vaughan and Menlove, there's nothing more that person could have done. But nevertheless, he's found liable. So we can say the defendant is negligent without saying that person was a bad person, without saying that person was careless, without saying that person should have done better, right? Because we're not making a judgment about that person at all. We're just making a judgment about whether the person lived up to the ordinary reasonable person standard. Okay, and as I say, the reason for that is because what we're trying to do is not justice to the defendant, but justice to the plaintiff and the defendant at once. Okay, that's our introduction to the ordinary reasonable person standard. Next time we're going to talk about circumstances where it isn't actually appropriate to apply this standard, because it isn't appropriate to apply any standard at all. And in future episodes, we're going to explore the standard in more detail. So thanks very much for watching. Hit like if this was of use to you, and please subscribe so that you can be made aware of future episodes. Thanks very much. See you again.